So a new case challenging the NFA and its restrictions on SBRs is now in front of the Supreme Court. And with Congress recently passing the $0 tax on suppressors and SBRs in the Big Beautiful Bill, this case just got even more important. So let's break down what is happening in this critical challenge. Now, before we jump into this video, if you guys want to support the channel, one of the new ways and best ways right now to do that is check out the free legal guide that I have available for you guys. Again, it's free to sign up. All you have to do is put in your email. And then once you put in your email, we send you over the free PDF. Also, we do some follow-up emails, every once in a while with additional free education. And then you can check out my website, armscholar.com. Over there, we have the free legal guide and other resources and things for you guys to check out. As I mentioned in the intro, in this video, we're going to be talking about a new case and an important NFA challenge that is now in front of the Supreme Court. This case is called U.S. versus Robinson, and it's a challenge to the NFA and its restrictions on SBRs. In this petition filed to the Supreme Court, they asked for the Supreme Court to find that the NFA's restrictions are in fact unconstitutional under the Second Amendment as they applied to SBRs. This is a case that was ruled on prior by the 11th Circuit, and the 11th Circuit Court of Appeals in that decision found that the NFA does not violate the Second Amendment. They found that the NFA's SBR restrictions are constitutional even in light of what the Supreme Court recently said in their Bruin ruling. This has now prompted the individual here, Mr. Robinson, to seek Supreme Court review, and he wants a reversal of that decision. The Trump DOJ recently waived their right to file a response to this case, and they said that they will not file a response unless the Supreme Court orders them to, and as of right now, this has been set for conference in September. However, recently, Second Amendment Foundation recently filed an amicus brief in support of the Supreme Court actually granting review to this case, and there is a high likelihood that the court here, the Supreme Court, will in fact order the Trump DOJ to file a response brief in this case, like they just also ordered the Trump DOJ to do in a different NFA challenge that is also pending in front of it. Now, the facts around this case are interesting. On September 9th, 2022, law enforcement officers responded to a complaint that there was a suspicious vehicle parked outside of a home in Florida. And when the police officers arrived, they observed the individual here, Mr. Robinson, who was asleep. He was in the driver's seat, asleep. And they also saw that there was a buttstock and a rifle that was next to him. Officers used their flashlight to view inside the vehicle. They woke up Mr. Robinson, and the officers ordered that Mr. Robinson actually place his hands on the steering wheel. And rather than complying with the officer's request, Mr. Robinson then decided to drive away. They followed Mr. Robinson, and eventually he stopped his vehicle and he was detained. Police officers recovered on search a loaded short-barreled rifle and a separate upper receiver of a rifle that was 16 inches in barrel length, and that was also within the vehicle. After officers gave him his Miranda warnings, Robinson explained that he had bought the rifle in Tampa Bay, Florida, and that he did not know that it was an SBR and that it needed to be registered. So they also searched the National Firearms Registration and Transfer Record, and they found that the rifle there, the SBR, was not registered in accordance with the NFA. He was then charged with possessing an illegal SBR, and after a bench trial, the district court found that Robinson was in fact guilty. They later imposed a sentence of 18 months probation and 6 months of home arrest, so he got house arrest, but Mr. Robinson then decided to appeal that conviction up to the 11th Circuit Court of Appeals. In its decision, the 11th Circuit not only rejected the Second Amendment challenges to the NFA's restrictions on SBRs, but also all of those tax arguments. And on the Second Amendment question, they relied heavily on the Supreme Court's Miller decision. They stated that Miller already found that short-barreled shotguns are dangerous and unusual firearms and therefore could be restricted. And they believe that there is no, significant distinction between short-barreled shotguns and short-barreled rifles, and therefore Miller stands for a valid precedent against those SBRs. They state that until the Supreme Court changes their decision or clarifies the whole SBR rule and the issue under Miller, they have to stick to Supreme Court precedent. In rejecting the tax argument, they claim that Bruin's decision forecloses that type of argument, since Bruin contemplated that some objective restrictions like fees and taxes and tests could be permissible under the Second Amendment. And they point heavily to dicta issued in a concurrence by Justice Kavanaugh, and therefore they struck down the whole tax argument that was brought up against the NFA. Well, now that decision is up for Supreme Court review. In the petition, the two questions presented for the Supreme Court to consider are whether federal criminal punishment of the possession of an unregistered short-barreled rifle violates the Second Amendment. And then second, also, whether the federal criminal punishment of the possession of an unregistered short-barreled rifle exceeds Congress's tax powers under Article 1, Section 8, Clause 1 of the Constitution and also violates the 10th Amendment. In the petition, Mr. Robinson rejects the notion that Miller stands for the proposition that SBRs are not protected arms. They argue that since SBRs are protected arms, the federal government actually bears the burden under Bruin to show that there is a history and tradition to support the registration and taxation for the mere possession and ownership of these types of lawful arms. They state that the government has not met that burden. They did not meet that burden down below, and therefore the Supreme Court should reverse the 11th Circuit's decision. They point out that the colonial era laws that the government used to justify the NFA have a completely different purpose. The purpose of those colonial laws was to make sure that the population was sufficiently armed, not to disarm them like the NFA actually does. Because of all of that, Mr. Robinson asked for the Supreme Court to grant review and to reverse what the 11th Circuit said and to ultimately strike down the NFA's SBR restrictions. Now, like I mentioned, recently the Trump DOJ waived their ability to file a response to the petition, and they indicated that they will only do so if the Supreme Court orders them to file that brief. The good news is that multiple two-way organizations have now filed amicus briefs in support of the Supreme Court actually taking review to this case. SAF in their recent amicus brief argues that the Supreme Court frequently deals with some of the most complex legal questions of our time. This is not one of those issues. A short-barreled rifle, an SBR, is indisputably an arm under the plain text of the Second Amendment, and so any restriction on it must comport with history. Because the 11th Circuit failed to engage in historical analysis, it must be reversed. Further, the particular restriction imposed here, an onerous tax, has no distinctly similar historical laws to point to, and it too must crumble. This petition provides a low-pressure way for this court to begin to clarify that the Second Amendment does indeed apply to all commonly owned bearable arms, something several members of the court have already indicated they are interested in doing. And there they point to the recent statements in the Snopes denial, saying that, from Kavanaugh, that the time will come soon in a term or two where the Supreme Court will need to address these types of issues. They state that there has been enough percolation and the results are clear. Lower courts in several circuits will keep reaching unserious rulings in order to do everything they can to undermine the Second Amendment and this court's ruling in Bruin. Further percolation is of little value when lower courts in the jurisdictions that ban AR-15s appear bent on distorting this court's Second Amendment precedents. SEF argues that the Supreme Court need not take Amicus' word for this. Several judges in the lower courts have criticized their colleagues for giving a judicial middle finger to this court when it comes to the Second Amendment. The petitioners make a compelling argument for why certiorari is appropriate here in this case. Amici submit this brief to emphasize 1. Why SBRs are plainly arms under the Second Amendment, 2. The lack of any historical tradition to support the NFA's restrictions on those items, and 3. How the 11th Circuit misunderstood Miller, and finally 4th, the importance of this court confirming that special taxes on protected arms are unconstitutional. So this is now the second NFA SBR case that has been put to the Supreme Court dealing with the Second Amendment and trying to strike it down based on the Second Amendment. It's important to note that the other case, the NFA SBR challenge Rush versus the US, in that case, the Trump DOJ also tried to do the same waiver of the response, but the Supreme Court ordered that they needed to file that response. And the likelihood is that that is also going to happen in this case, meaning that 2 NFA SBR challenges will be briefed and then will go to Supreme Court conference. The recent NFA tax change might now also create a unique enough dilemma to get the Supreme Court interested in this type of issue and to finally address this. They've stated in the prior denial of Snopes that they want to address these whole armbands questions. Whether or not they're going to do that through an SBR challenge or they're going to do that with a ban on so-called assault weapons is yet to be seen. But right now, you have 2 cases dealing with the NFA and SBRs that are in front of the Supreme Court. The Supreme Court has shown some sort of interest in this SBR issue with the prior case, Rush versus US. And now you have another similar one, which has Amici pushing the Supreme Court to address this issue finally and deal with whether or not the NFA is constitutional and whether or not these types of restrictions can be placed on these types of commonly possessed arms. So that's what's going on in this new NFA SBR challenge in front of the Supreme Court. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, again, like I mentioned, armscholar.com. Over there, we have the free legal guide that you can sign up for, and then other things that you can check out over on the website as well. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.